Aye.
Hello, what's your name? Yeah.
Hello, Your Honor.
What's your name?
I'm Jeanette Thompson.
What did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with three different women.
Today's case is one of the strangest you'll ever see from Judge Simpson's courtroom, and that's saying something. We have Larry Lee, a defendant who started the day determined to represent himself, only to suddenly reverse course and ask for a lawyer halfway through the hearing. What triggered the change? Missing discovery files, an alleged breakdown in communication with his previous attorney, and, oh yes, a surprise witness confrontation that had Judge Simpson putting his foot down. The twists don't stop there, because in this hearing, the legal drama is tangled up with behind-the-scenes grievances, strange FOIA requests, and accusations that spill over into the courthouse hallway. Stick around. You won't believe how this one ends.
Court does call the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Retail Assistant Prosecuting Attorney on behalf of the people.
State your name, please, sir.
Larry Lee.
Mr. Lee, you are here for your preliminary examination. Sir, you have elected to represent yourself. Is that still your wish, sir?
Your Honor, I have not received any of the requested discovery material. I've sent out written requests for the prosecution and our previous attorney and haven't received anything. So at this point, I'll be needing an attorney to assist, to represent me.
Your Honor, if Mr. Lee can maybe put on the record where he sent that request. I have not been informed of the discovery request from him. My understanding was that Mr. Burgess had a discovery materials.
I sent it to 200 North Main Street.
But well, there are two issues really involved. You sent out that you wanted a copy of your discovery.
Yes.
Are you indicating that Mr. Burgess did not provide or share with you your discovery?
Correct. I sent out one to the prosecutor and one to Mr. Burgess.
Now, I'm asking a different question. At the point in time that Mr. Burgess is representing you, are you saying that he did not share the discovery information with you?
The only thing that I received was a police report, a 2-page report. That's it. So I didn't receive the file that he was referring to last court hearing. I didn't receive that.
This is a big turning point. Larry Lee has the constitutional right to represent himself, but that decision comes with risks. Judges often warn defendants that self-representation is like performing your own surgery. Possible, but almost always a bad idea. Here, Judge Simpson made sure Lee understood his options, and Lee chose to bring in an attorney. Now, some might see this as backtracking, but in reality, it's often a smart move when discovery, meaning all the evidence the prosecution has, hasn't been fully received. The problem? This last-minute shift means delays, inconveniencing witnesses and the court. But Judge Simpson is bound by law to allow it.
All right, let's just cut through the games and charade here. Do you wish to be represented by an attorney?
At this point, yes, I don't have any material.
Well, it's not an issue of the material. Do you wish to have an attorney represent you?
Yes.
Okay, under the court rule, he is entitled and can ask for that at any point in time. This is probably going to cause great inconvenience for people, and now here's the weird part of the system. While Mr. Drukas, I appointed as standby counsel, I need you to get to the MAC office and see what we can get. All right, take it back. We'll get that resolved, figure out what the MAC office wants to do.
When we come back, I just want to make sure I don't forget, there are a few cases that you want to address that happened after the last court hearing, but we can do that when we come back.
Something that happened after the last?
Yes, Your Honor.
You were just full of surprise. It's fine. I'll deal with it then. Court's gonna stand in recess.
All right.
Um,
On Marie Tanner, Assistant District Attorney, I'm Alex Siegel.
Good afternoon, Edward Lucas on behalf of Larry Lee.
all right. And Mr. Lee, I've signed the order appointing Mr. Dukas to represent you in this matter so that you're aware. Okay, all right. So in this matter,
Set for a preliminary examination, I'm asking for a brief adjournment. I understand through timing with the court that Monday morning would be available. If we could set it for that time.
All right.
Opportunity to go over discovery.
will that work for the people?
Yes, Your Honor. We'll have witnesses present.
All right. So preliminary examination in this matter will be adjourned. Court finding good cause to do so. I will adjourn it to, what is it, the 11th?
Yes.
August 11th, 2025, 9 a.m.
Thank you, Your Honor.
For me.
When the court's ready, I have a couple of matters to put on the record.
Yes.
Your Honor, first and foremost, after the last hearing we were here for, the victim was present with a support person. As they were leaving the courthouse, they were addressed by someone who identified themselves as the friend of Larry Lee. I believe that person is now sitting in the gallery here today. I personally warned her, but I would appreciate it if we could repeat that on the record that.
Now here's where the case takes a very odd turn. A woman in the gallery, apparently a friend of the defendant, is being confronted about an interaction with the alleged victim right after the last hearing. Even though she insists it was just a friendly check-in, Judge Simpson isn't having it. Why? Because in legal terms, any contact with a victim can appear to be witness intimidation, even if it wasn't meant that way. And here's the kicker. The judge makes it clear that even perceived intimidation can reflect back on the defendant. What do you think? Was this harmless curiosity or crossing a legal line?
The victim is not to be talked to or contacted. I don't have anything indicating that Mr. Lee directed that contact, but I want to make sure everybody's clear so we don't have any further issues regarding contact with the victim of this case.
All right. And which individual are you referring to?
This lady right now.
Emma, you come out this way, please. What's,
Hi.
hello, what's your name?
Hello, Your Honor.
What's your name?
I'm Jeanette Thompson.
What did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with 3 different women. And since he was staring at me, I said, are you so-and-so? I could identify him. So I think he was just irate because of what he going through. I don't know. But to be honest, I don't know that man. When he was talking, he was using verbal language. He walked back towards me and 3 other women and was kind of upset. And I said, I just want to know if you okay. My bad. I could identify him. That was all it was. I just said, I just want to know you okay. I don't.
Okay, so just stop it right now.
Yes.
So I don't want you to have any contact with the alleged victim in this case whatsoever. It doesn't matter if you are worried about whether or not they're doing okay or anything along those lines. You just not to have any contact. Because ultimately, while the people don't have proof that Mr. Lee's involved with that, it could be attributed to him in regard to the behavior, and I don't think you want that to occur. All right? So I don't want any contact whatsoever. Am I understood?
Yes, sir.
All right? And if I do find out there is, at minimum, I would have you report.
Well, please, can you tell him not to walk up on me
I am
again?
not gonna tell him that.
Okay, because that was
You
just
are, well, hold on. Here's part of the court proceeding.
right.
You are not.
Correct.
So you need to, if it's necessary, you need to get out of his way. There's court security if that
Got it.
becomes an issue for you.
Okay.
Or you can just make the election that you do not need to appear. If you want to see the proceeding that is happening with Mr. Lee, then certainly you may view that on YouTube. So there isn't a reason for you to be here.
Mhm.
There is a reason for him to be here.
Got it. Okay.
Understood?
Yes, sir.
All right, thank you. You can have a seat.
Thank you, Edward. One other thing regarding the discovery request that Mr. Lee said he had sent one to our office.
Just when you think you've seen it all, the prosecutor reveals that Lee filed what he labeled a FOIA, that's Freedom of Information Act request. But it wasn't just for police reports. He wanted all communications between the prosecutor, the court, and his former lawyer. Plus, he's filed a grievance. This is highly unusual in an active criminal case because FOIA requests are normally for public documents, not privileged communications. The judge doesn't dive deep into it here, but this could hint at a bigger conflict brewing behind the scenes. It's another layer of complexity in a case that already feels like it's part legal drama, part procedural chess game.
I just received the email. It was labeled a FOIA request, so it went to our appeals and FOIA department. It appears it's a mix of, and I'll make sure to share this with Mr. Drukas, but essentially, it appears he is attempting to FOIA communication that I may have had with the court, that I may have had with Mr. Burgess. There's also a grievance / investigation request looking to, it appears, grieve me, potentially more people. I haven't read through the whole thing. Somewhere in there, there's mention that he wants anything related to this case, but the overall idea and heading is FOIAing all communications that have happened in this case, as well as
So here's where we leave it. Larry Lee now has a court-appointed attorney. The preliminary exam has been pushed to August 11th, and both the prosecution and defense will have to tread carefully when it comes to witness contact. Add in the FOIA request, the grievance filings, and the emotional tension in the courtroom, and you've got a case that's bound to get even messier before trial. The big takeaway? In court, the drama doesn't just happen during testimony. It can spill out into the hallways, the paperwork, and even the relationships between lawyers and clients. If you found this case as strange and fascinating as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.